The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. We're here for oral argument in case number CV 18732, Zandell versus Zandell. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs and we have discussed the case in conference. So, counsel, you may proceed.
Thank you, Judge Cruz. May it please the court, Jared Sandler on behalf of Jay Zandell, appellant. I'd like to reserve 5 minutes approximately for my rebuttal time. As briefed before this court, Father asks the court to reverse and remand the October 10th, 2018 ruling by the trier of fact for a new trial due to two essential errors of the trial court. The first being the failure to make findings on the record regarding ARS 403, the factors for parenting time and legal decision making. And the second is due to the due process issues related to his default and subsequently the court not allowing him to participate in the default hearing itself.
Generally speaking, when a court issues a default, we're talking about a judgment. Was that what she did here? She didn't. Did she enter a default judgment at that point in time?
The minute entry order record is not as clear on that, but the transcript, no less than 3 times, the court referenced default. That's what we call a default, sir. You've been defaulted. So the oral order of the court directly referenced a default and default judgment.
So this is a default judgment in your opinion?
The court proceeded as though it were a default and did not allow him to participate, nor did he allow him to introduce his own evidence and dismissed his own petition. So I suppose he filed his own petition, although not required to file a response per Rule 91, he filed his own petition in this. So there were 2 separate counter petitions. I believe the record reflects that the trial court dismissed his own petition and defaulted him as to mother's petition and did not allow him to participate. So essentially, I would posit that both of those would be due process violations.
Well, I guess my question, and then I think Judge Catani had one on the same vein, is if we remand it, are we remanding it back to at the point in time where she entered the default for further proceedings, or are we simply vacating the default? And what's the basis to vacate a default? Is that if that's actually what she did? I mean, he failed to file the pretrial statement, and in fact, that was an order that she said that she would do if he failed to file the pretrial statement.
The relief that would be demanded would depend on the due process violation, in my opinion, and what it stems from. And that's part of the problem with this case is it's not abundantly clear which portion stemmed from what. My brief obviously discusses the power under contempt and the power for discovery and touches on Rule 76.
If we were to send it back, if we were to agree that there's a due process violation and not being allowed to cross-examine mother, would that mean we would have to do something about the court's order precluding him from presenting evidence? Is that a reasonable sanction for violating an order? Why wouldn't it be a reasonable sanction, I guess would be my question.
So that is the ultimate question, but the court did not even get there. I believe that the case law calls that the court is required as a part of due process, and as discussed in Cook, the 2 components are notice and meaningful participation. And meaningful participation would mean both testimony and exhibits. And when you remove someone's due process, you need to look at the reason why. It's not supposed to be punitive. It's supposed to prejudice the other side, and you're supposed to not be able to have any lesser sanction to that. And the court did not even consider whether it would be prejudicial to mother, whether these were exhibits mother had notice of that she had no objection to.
Was there an argument made that mother was on notice that there's no prejudice from the lack of a pretrial statement?
I believe the transcript references the father was asked if he had provided them, but was not afforded the opportunity to list whether or not he believed there would be a prejudice there. And secondarily, the court looked at if there's any lesser sanction. Could there be a continuance? Could portions of the evidence be excluded? And by failing to consider any of those and using the ultimate legal weapon against father here, he created a situation where it does beg the question, how far do you rewind the clock on this? And it's father's position that that would be rewound to the initial order, and there would be a trial based on the merits at that point.
At a minimum, you're suggesting there would need to be a finding that mother was prejudiced by the lack of the pretrial statement.
Yes, and then after that finding, there would need to be a finding that there was no other way to cure that prejudice other than a true default. So in looking at the issue as to default, as mother has argued, under a traditional default, there's a distinction between someone who's been defaulted for being non-responsive and defaulted due to a sanction. And that's articulated well in the Sears-Roebuck case. And in this matter, father was a participant through and through. And 403B is triggered when there is a contested case. And I believe the phrase case there is materially important. It's not a contested hearing. It's not initially a contested matter. And this case undoubtedly has been contested. Mother filed her own petition, and as I referenced, even though father is not required to file a response, he filed a counter petition. The parties actively engaged in intended mediation, and he actively attended the hearing itself. He participated and contested the case up until that final sanction, and thus the 403 factors were required to be placed on the record, and the failure to do so prejudices father and frankly ultimately the children as well.
Do we need to get to whether findings were required if we make a finding that the underlying process was unfair, that there's a due process violation in father not being allowed to cross-examine witnesses?
I believe all paths lead back to the same road, and that would be a new trial beginning on the merits, either way.
Isn't it true that ARS 25-411 does not specifically require that there be findings made? Why should we, if we go that far, decide that 403 findings must be made?
I believe that Reed v. Reed discusses that the 403 findings are not only important as to the creation of the best, in order in the best interest of the child, but it's also the benchmark or the watermark for where future modifications would be. And 411 requires the movement to meet the burden to show there's been a significant ongoing change of circumstances. And were we not to articulate all of the factors, as this panel is aware, at trial people are providing very disparate testimony, different exhibits, and without the court actually finding they believed mother over father, this exhibit, it would be impossible to determine where the watermark was for future modifications, what the circumstances were to be modified from. And so if future subsequent changes did not include that, you'd have a moving target for everyone, and I believe would flood the court with everyone believing their circumstances had changed when there was no objective findings that had been made by the court.
Well, there was no competing testimony in this case.
That's true, and I would argue that that was due to some potential due process violations to my client. Turning over to the default itself and the 403 factors, even if this court itself were not to find any due process violations and remand simply on the 403 factors, father posits that that would require a new trial under these circumstances. And this is not a box. This is not a red car, blue car accident. This is a living, breathing family with 2 children in it. And the order from October 10th, 2018, if now subsequently remanded back in what would likely be 2020 to make findings. Ironically enough, the first 403 factors, the past, present, and future relationship between the parents and the children. And that finder of fact would certainly not be in a place to make any discussions about what had happened this past year, what the present relationship is, or be in a good position to discuss what would happen in the future. And so it would be a perfunctory, a form over substance remand that would not provide, respectfully, justice to father or the children. Discussing the 2 different potential types of sanctions under which father, the contempt sanction, which was by this court found inappropriate when removing information that would be critical to the children in Hayes v. Gama. Father's testimony undoubtedly, as he said would include information about the children, his relationship with the children. I believe the sanction to default him and dismiss his own petition fails under contempt. Even as redefined by Johnson v. Purveyor, the key distinction in Johnson is that the subsequent report by the custody evaluator was not deemed to make a material difference on the case. Here, one side's complete input against the other on what happened with their children undoubtedly has an impact on that, and I believe this case is more akin to the James A., where there was one critical placement bonding study done, and the exclusion of that was found to be an error by the court.
What kind of record did mother make, if any, regarding prejudice from the lack of a pretrial statement? And I realize it's father's error in not providing one, but was there some discussion about this is why I'm prejudiced as a result of not seeing?
As occurs frequently in a situation with two pro per litigants, the court takes a more active role, and in doing so asks questions of both litigants, and the court directed the questioning regarding the filing of the pretrial statement, if exhibits have been exchanged, and each party appeared to dutifully answer. So the questions directed to mother appear to answer the question whether she received it. I don't believe the record indicates that she explicitly said.
But did the court ask her, how are you harmed by not having received it, or did the court go through the information that, I guess it's hard to know if father has never filed anything for the court to ask questions, how are you prejudiced by this?
I believe the record will show the inquiry ended at if she received them.
I'm sorry, miss?
I believe the inquiry from the court ended at did you receive them, and mother's response ended at she did not receive them. As referenced in mother's brief, she indicates that Rule 76 potentially is the reason why father could be defaulted on this, and it's not a discovery and disclosure issue. Respectfully, the rules of family law procedure do not operate in a box. They operate in conjunction with the other rules and statutes and case law. And in doing so, providing notice only does not cure due process issues. Should a court give such an important order that with notice that a person of a certain race or religion could not present evidence, the notice provision would be met, but certainly that would not pass scrutiny. It both requires you don't leave your rights at the door simply once you've received that notice. And this court has refused to take those types of logical jumps to an absurd conclusion. I would reference Leathers v. Leathers. This court found in a niche issue regarding insurance that an issue that was not discussed pre-trial or at the trial led to the issue not being able to be resolved. And the family law bar took that and jumped and said, if you leave it out of a pretrial statement, any issue that cannot be discussed at trial with the judge, and you've essentially waived that issue, much to the chagrin of everyone's malpractice insurance. And the court came around nearly a decade later and annulled and held that, no, that's a wrong interpretation of that simply not placing something in a pretrial statement does not divest the court of its obligation under 25-318 or the party's rights under 318 to have their property divided. And that an asset that has not been listed in a pretrial statement is still divided between the parties. And that type of form over substance that we believe that mother is articulating here should not be followed in this instance, as this is a due process violation. And even under these circumstances, where father on the record admits he does not have a great relationship with his children, even where his frustration is palpable, it's our job to protect the due process rights of the people, whether we like them or whether we don't like them, whether the outcome would be different or would not be different. And the second we begin to erode those simply because we give a portion of someone due process notice where we think that, well, the outcome might not have been different anyway, I believe that's a slippery slope down to adjudicating whether someone gets that due process. And I believe that's against the fundamental tenets that we stand for. I'll reserve the remainder of my time for rebuttal.
Thank you, counsel.
May it please the court, good afternoon, counsel. My name is Thomas Alonji, and I represent the respondent and appellee, Jennifer Zandell, and she's present here today in the gallery. No need to reserve time because this is all I get. I would like to start by framing this in the sense that this case, in a lot of ways, forces us to talk about what does it mean to be defaulted. Because there is some contradiction, and I applaud my colleague. His briefing was smart and was well written. But I think in the end, if we're going to have any meaning attached to the word default, there has to be some consequence. I will now answer, to save you the trouble of asking, the same question you asked my colleague, which is, do you think this is really a default judgment case? I think I have to admit that, even though the judge didn't specifically use the words, I'm entering default judgment, it would be almost dishonest of me to come in here and say, well, she didn't really hold him in a default judgment, because sure she did.
So at what point exactly did that happen?
It appeared to me right from the start, and I think counsel would agree with me on this. I got the transcript here, and right out of the gate, in fact, it's right on page 5, the court, in fact, it's the very first page, the court began talking about the party introductions. The court says this is the time for a trial, acknowledges that there are 2 competing petitions for modification, and then mentions the fact at the bottom of page 4 of the transcript that she had issued a minute entry, and the last 3 lines of page 4 plunges into a discussion about how she had entered a number of orders, including one directing the party to file a pretrial statement, exchange exhibits, witnesses, and then she goes on to say to father, I have nothing from you. So it wasn't just the absence of a pretrial statement. He didn't do an affidavit of financial information. He didn't do a pretrial statement, and he didn't even bring in exhibits.
Could I ask you about that order?
Yes, Your Honor.
The initial order, it references default. It says there are available sanctions if you don't comply with this order, including proceeding to hear this matter by default based upon evidence presented by the appearing party. When I read that, it makes me think default means someone doesn't appear. And that seems more traditional view of what a default is, somebody who doesn't answer and doesn't show up. And here we had someone who answered, in fact, filed their own petition, and they showed up. And this very language says we're going to grant a default to the appearing party, which suggests that, so if you don't show up, you're going to be defaulted. So how would you be on notice that you're going to be defaulted if you file the petition and you show up?
In a couple of ways, and in answering that question, I will concede another point that I think I have to concede. I don't ask this court to treat this the same way you would treat a default where someone doesn't answer at all. Clearly, there is a distinction in the case law. The Sears case points that out. There were other cases in the briefing as well. But the way a person's on notice is twofold. First of all, everyone who walks into the courtroom is held to be familiar with the rules and held accountable to following them. And even though the court didn't specifically cite Rule 76, Rule 76 does in fact say, and doesn't mention default at all, it says if you don't do these things regarding a pretrial statement, here are the possible penalties.
Actually, it does mention default specifically.
But not as a precondition to what the court can do. That the court can strike a claim. The court can refuse to allow the party to present evidence regarding a specific claim. That the court, in other words, it gives the court lots of options.
No, it does say, number 6, rendering a default judgment in whole or in part against the disobedient party.
No, I agree it's in the rule.
Okay.
But I don't think the court, I guess in this case it wouldn't matter because we all acknowledge that the court did use the word default. But my point is that even if Rule 76 itself didn't refer to defaults in particular at all, my argument would be that both sides, mother and father, along with any attorney they chose to hire, would be responsible for knowing the consequences if you don't do a pretrial statement.
But how do we get past, I understand the consequence of you haven't turned over a pretrial statement, and presumably if there's something that's prejudicial because the other side hasn't had an opportunity to look it over, seems to me you have to make that finding. But even assuming you make that finding, why wouldn't the remedy only be you don't get to present evidence? How do we get to the next step of you also don't get to cross-examine witnesses that are put on by the other side?
A couple ways. First, and this is answering your question, I promise. But it also addresses the other question you asked a moment ago, which is at what point did the court handle the issue with the exhibits in pretrial? The court actually interrupted Father. It's on page 5, because Father began to talk about how, well, I have some exhibits here, but she's seen them, and then he starts to qualify his own statement. And the trial court cut him off and said, actually, the challenge is coming from me, the harm caused to the court by not knowing what your claims are going to be. So I
Okay,
think...
well, hold on for a minute on that one.
Yes, sir.
Because the court isn't presenting evidence. And if we're talking about this is a failure to provide notice, it's notice to the other side, not notice to the bench, because the bench gets to hear it when it's presented. So, and I want, in that vein, if he had simply filed his pretrial statement, and we'll use air quotes on that, to say, the position I'm taking is that I filed in my petition, and the exhibits I'm going to offer are all of Mother's exhibits. What lack of notice is there in that hypothetical?
If that's all he ever does, none.
Okay.
But a pretrial
And in
has
this case, do we know what exhibits were excluded?
No.
Well, how can we, and Mother wasn't given the opportunity to explain, I don't know what that is, because the bench cut her off, right?
Didn't cut off Mother.
But cut off Father to say, because he said, she's seen these.
And then he
And
started to
isn't-
qualify himself.
Well, isn't the question then to Mother, have you seen these and do you know what's in them? Isn't that should have been the next question
I think the
from
court,
the bench?
the court
From the bench?
could do that. I don't know that the court had to. And the pretrial statement, and if the court will permit me, I do want to develop the idea that there was also a separate concern with the bench. You are right when you say that the primary concern is to put each other, the parties, on notice what a person is going to claim, what's their evidence going to be, witness exhibits. But the bench also gets an important benefit from a pretrial statement, when it's done right anyway. They are told what the objections are going to be. They are told who the witnesses are going to be, and more importantly, who the witnesses are not going to be. They
But
are
let's say
informed.
you just haven't filed one with the court, but the other side agrees, yes, I received their pretrial statement, and the court just didn't see it. We're not going to preclude the party from presenting evidence under that scenario, are we?
I don't think so. I wouldn't
And
be.
how is that different? Isn't the relevant question, are the parties in a position to address each other's evidence?
I guess the way I would answer that is that if those had been the facts in this case,
But they're not the facts because the trial court didn't ask the parties, what's in there? Other side, are you aware of what's in there? Is this prejudicial?
we know that Mother didn't get the pretrial. We know that much because Father himself, when confronted, where's your pretrial, specifically says, I've been out of town, haven't done it. There was no moment where he even pretended that he had done it and that my client was aware. He did say that he thought the exhibits were known to her.
Well, I think that's the point we're all trying to stress is if he had said, my exhibits are tax returns, or my exhibits are these letters that she's written to me. Well, there's no lack of notice there. She knows what's contained in there, but as long as they're joint tax returns, I should quantify that by saying. But the point being is we have nothing in this record, do we? And the trial court, before she entered the default, had nothing.
Well, two thoughts on that. First of all, I think it's important not to jump to the conclusion that Mother did in fact have all these exhibits before. He started to say that on line 11, page 5. He says, quote, I have a copy from Mrs. Zandell. There's nothing in here that she's not seen. There may be some communications perhaps, and I'm certainly open to any if she has any challenges. So it's almost as if he recognized that she actually didn't have all the exhibits, that there were.
But she didn't say, there's something in there that I've never seen.
Well, she was never given the exhibits at all. And my point, I guess, in point number 2 where I was getting at was that if there was a defect in that arrangement, if there was a failure to do that, I think the court could have gone there, could have asked those questions. But in the end, it was incumbent on Father to say, well, Your Honor, if you're not going to let me use these exhibits, I at least want to make a record of what those exhibits would have been, an offer proof. Exhibit 1 would have been this. It would have shown this.
Okay.
And if the court didn't let him do that, at least put it in writing afterwards.
Let me ask, I think we're just all coming to one question surrounding the issue of prejudice. So in other words, is it your position that once the party fails to file a pretrial statement in proper form, then Rule 76, now B, is in play and the court can do any of these things just unfettered? There's without restriction, the court can impose any of these sanctions, regardless of prejudice, regardless of any other factor. Is that your position?
I think the short answer is, by and large, yes. I do think the court has to honor certain case law.
Okay.
About.
Let me stop you there.
Okay.
Because the sanction imposed here was finding him in default and also striking his pleading, his petition. But there's one additional, number 7, scheduling a proceeding to treat the violation as contempt of court. You're familiar with contempt of court? What's the maximum punishment for contempt of court?
Well, for civil, contempt of court is supposed to be remedial only. There is no punishment. Rule 92 forbids contempt as a punitive measure. It's designed only to fix the problem. So my position would be there would be no fine per se or incarceration because it would be illegal.
So
if that's the kind of contempt that's how I read that contempt.
So then what does that mean? The court could find a violation as contempt of court and schedule proceedings. What does that mean?
If the court chose to go in that direction, I think the court could say, sir, I'm issuing a show cause order. I'm asking you to come back to court on so-and-so day. Give me some reason to believe why you should not be held in contempt of court and what remedies you think I should impose to make sure that mother gets the material she's entitled to and that I get the things I should have gotten. And at that point, I think the court has to evaluate in its own mind, how much am I hurting mother's case by delaying this trial and hurting the children simply because father chose to not do any things he was supposed to do. It's implicit.
So then you concede that there's some analysis that needs to support the decision the court makes rather than simply it's 1 of 7, I pick 6, and we go, right? There's some analysis. There needs to be some support for the sanction that the court is selecting.
The short answer is yes, but I don't think the court is obligated under the rules to specify in writing what that analysis is or even announce it. I think the judge
So then how do we know if the court abused discretion?
By looking at the circumstances and looking at the result and deciding that was too much.
Well, can we look at when you're striking the petition? The petition had been filed and certainly served on the other side. So what's the basis for striking the petition? If doesn't the petition provide some notice to the other side? I think we're all struggling with why isn't there some requirement that the court, we're not suggesting that mother did anything wrong, but why isn't there some requirement that the court figure out whether mother has been prejudiced by the late disclosure to the extent it's going to be disclosed at that point? If he comes forward, why shouldn't we require some finding of prejudice?
I think you would be scripting a requirement into the rule that doesn't exist. I think it's a best practices issue. If I'm sitting on the bench and this situation presents itself to me, I would have liked to have said something on the record saying, sir.
Well, can you get to the next point? The next question was,
Sure.
How is it justified to preclude somebody from cross-examining the other side? Let's say they didn't submit their own evidence, and it's okay to say we would affirm a trial court's decision not to allow one party to admit evidence. How would we ever get to the next step and say, and also you don't get to cross-examine evidence from the other side?
The Christie case? The short answer there is by allowing someone to do cross-examination, you are implicitly letting them spin their theory of the case through questions asked of the opposing side.
But it's not spinning. Aren't we trying to
that
find
word.
out? Are we trying to find out whether the evidence is competent that's being submitted? And we find that out through. Certainly, the judge can ask questions and wouldn't we want the other side to ask questions? That's different than cross-examination is different than offering your own evidence, but to be able to challenge what someone else presents seems very different than a sanction of I'm not going to allow you to present your own evidence.
It's different for sure, but I don't. And the reason why I mentioned Christie's, I recognize that Christie's a case where they said even if you default, you should be allowed to participate with cross.
Well, and the new rule specifically says that.
The new rule does.
44.2D specifically says, even if you're in default, you get to cross-examine if you show up. But it goes beyond just cross-examination. The new rule does. And I know it wasn't in effect at the time this happened. But the new rule says you must allow the party to participate in the hearing to determine what relief is appropriate or to establish the truth of any statement. So to participate, doesn't that require more than just cross-examination?
Not even according to Christie. Even in Christie, where someone's parental rights were on the block for termination, the Court of Appeals held that participation meant not kicking the person out of the courtroom, which even this judge didn't do, and allowing them to do cross-examination. But
So-
even...
I hate to interrupt, but we're just moving so fast, I'm afraid I'm not going to be able to ask my questions. But, so you conceded that at minimum, he should have been able to cross-examine.
Not necessarily. It wasn't the rule at the time. I think it's a better practice. I don't think it was
They
required.
announced a new rule, Chris?
Even under civil contempt. I mean, even just traditional contempt.
I think it depends on the facts of the case. The circumstances here, to me, back up what the court did. Because
What legal authority is there for the proposition that a defaulted party does not get to cross-examine?
None, either way.
Well, no, there's plenty the other way.
Well,
I
but the Christie case is distinguishable in the cases that go with it. I could find no family court
How is it
decision.
distinguishable, though, if we're saying there is a penalty, but you get to be here and you get to cross-examine?
Well, there were three differences in Christie. First of all, her parental rights were facing outright termination, so the danger was extreme to her, and that's not true here. Secondly,
It's not a significant right, the parenting right, the
It is-
rights at issue here?
it is indeed an important fundamental right.
So why would not the same considerations apply? Why would cross-examination be taken off the table?
By itself, that might not be enough of a reason to draw the distinction, but there was more. In Christie, the mother's behavior was simply a failure to appear. There was no accusation of failure to make disclosure, failure to give fair notice to the other side of what your claims were going to be. You had a state agency trying to terminate the parental rights of an absent parent. Here you had a litigant who, by all accounts, disregarded every single important function he was supposed to do after the date of filing a bare bones petition.
But that again gets back to, we don't really know if what he didn't do was prejudicial.
Right, but
Because he didn't have to file a response to begin with. He did more than what he was required to do.
No, but my point is that you had competing petitions. If we're talking about his petition being dismissed, and I think they're trying to argue that the dismissal of his petition was also a violation, my argument is when you file a petition, you are doing notice pleading. That does count for something, but I don't think any honest attorney would pretend that what goes into a pretrial statement remotely resembles what went into the initial opening petition. It's not supposed to. So my point is that when he decided that the only thing he was going to do was file a petition and then show up for the day of trial and say, well, here are my exhibits, and she kind of knows where I'm coming from, I would like to have seen the judge say, okay, what claims are you presenting today that are not in the petition? Where are you going to go, sir?
Do you have any case that says you can preclude evidence without some showing of prejudice? I thought the case law was pretty explicit that before you can preclude evidence, you have to show something that would indicate prejudice to the opposing party.
As a generic civil justice matter, there is case law, all kinds of it, but I think
Do you have a case that would say that?
I don't have a case off the top of my head, but I agree that there is a line of cases that talk about when it becomes an abuse of discretion for the court to exclude exhibits. But before the court can do that, father has to tell the court, hey, this is what my evidence would have been. How can the court make a finding that mother is harmed by the exclusion of evidence if father didn't even make a record of what that would be? He simply... Now, I agree he didn't have to file a motion to set aside default judgment. Counsel mentioned that in his reply brief, but I think he had an obligation at least to say, either there in the courtroom or in a supplemental filing after, this is what I wanted to present. You didn't let me do it. Please let me fix this now before I take up an appeal. Instead, he walked out of the courtroom before the hearing was over and did a notice of appeal and took it up to your honors.
As long as we're treating folks just to the same standard as lawyers, couldn't mother have said, I'd like to make a record of the prejudice that results from my not having that stack of papers he has that he seeks to introduce?
I guess I don't know what you would have her say in terms of the prejudice if she didn't know what the stack was.
We don't know if she did or didn't.
I think we do know from the transcript, because it was clear that he said, on page 5, he's clearly talking about, he says, quote, "I do have the exhibits if you care to review them. I have, present tense, a copy for Mrs. Zandell." But certainly from the transcript, there appears to have been no moment where he said, "Can I give her a copy here? Can we talk about these exhibits?" And I think he owed at least that much. If these rules, these requirements, these are important protections. That's so that the Jennifer Zandells of the world, I have no time left, the Jennifer Zandells of the world, when they walk into court with their kids on the line, counsel's right about that, that they have to have, they ought to at least be able to know where the other side's coming from.
Well, except, counsel, I believe the presiding judge is going to give you a couple more minutes. But it seems to me that the objection is not the benches. The objection comes from the party. And so the correct approach in this case should have been, I have some exhibits that I would like to offer. And the judge says, fine, show them to the other side. And now after the other side has reviewed the exhibits, the judge to ask her, do you have any objections to these exhibits? And if she says, I have objection because I've never seen these before, whatever, then we have a record. But by the judge inserting herself into these proceedings, we don't have a record, and yet we're asked to salute it for potential prejudice. Isn't that pretty much how it should have worked if we're actually talking about what would have been a much better practice?
I agree, that would have been the better way to do it. I don't know that she had to. And if I can put it this way, even if he takes the exhibits out and goes through them one by one, and we don't know how many there were, but let's say there was just a batch of 15, 16 of them, and she allows the time, the judge, to go through all these exhibits and takes mom position without talking about whose time that's going to come off on the court clock, that still doesn't address the issue of the claims that go with those exhibits. I could hand you right now my client's 13 exhibits and say, here are the exhibits my client used, but there wouldn't be much context. You'd have to parse through them and figure out, okay, he or she must be using these exhibits because it proves this point or that point. Well, we've all been in court long enough to know that there are certain exhibits which are being introduced for reasons that don't appear obvious on their face. So I don't know that it really solves everything. It would certainly solve some of the problems.
But at minimum, counsel, even if the judge said you did not submit your pretrial statement and you did not specify witnesses or exhibits, so no witnesses for you, no exhibits for you, but at minimum, why not let him cross-examine? That, I think that's a sticking point. That's a big problem. Where did he lose the right to cross-examine?
I think that would have been the better way to do it. I can find no family court case where this constellation of facts occurred, where someone didn't do any of the things they were supposed to do, then did this, and I'm not sure that the remedy would be a new trial anyway. I think that the appropriate, if you were going to reverse on any basis and send it back down for anything, it seems to me that the way to handle it would be to send it back down and conduct the inquiry, to have the court ask of father, okay, you heard this testimony, I'm going to go through the best interest factors, answer my questions.
And I know you're out of time,
Right.
but I did have one more question.
Sure.
I've read your brief as acknowledging that that detailed findings would be required if it were a contested matter, but you were suggesting that this is not contested because it was essentially a default.
Yes.
And so you agree that if he had presented evidence and there's testimony, that there would be a requirement that the court make findings?
That is my position, but even if you disagreed with me, and you might, 25403 subsection B requires only findings on the record. And if you look at the dialogue between the trial judge and mother, you can see that she's going through each of the factors. So if that's the basis for reversal and only that, then the solution is to send it back down and tell the court, hey, you got to make specific findings. We can see that you had that discussion with mother, make it official, do a new amended judgment, but that should not translate into a whole new trial for father.
Thank
It
you,
would-
counsel. I have been keeping track aside from the court clock, and we've done 4 minutes in addition.
Well, I'm grateful for that.
Roughly,
Thank you.
that we will add to your time. Thank you, counsel.
Absolutely.
And that's also the benefit of being on the afternoon calendar, where we don't have another argument right after. It's given us an opportunity. And of course, there you go. And counsel, you don't have to use all of it, but
If you give a lawyer the time, they'll generally take it. I'd like to make a key distinction here that I believe all of the case law shows is that discovery sanctions, disclosure sanctions are not meant to be punitive. And in this case, in reviewing the transcript, in reviewing the tone and tenor from the finder of fact, it feels punitive. There's no causal nexus between a prejudice to mother. There's not even inquiry to it between a prejudice to mother and a lesser remedy.
What's your response to the argument that, well, shouldn't at a minimum father make an offer of proof? So we would have a record. He is the one that wants us to consider an argument that the court improperly kept some evidence out. Usually we require an offer of proof. This is what I wanted the court to consider. You tell the court, I have these exhibits, this is what's in them. If you'd allow me to present them, this is what I would put before you.
I think under other burdens of proof, that would be required. In this, where it's the exclusion of evidence in a hearing related to the benefit of children under 25403, I believe the case law says you need to show a prejudice and you need to show that you looked at and considered lesser. And at the point where the court has not done that first, I believe that had the court done that, I believe the burden would shift to father to then make an offering of proof.
Oh, wait a minute. So just so if the court had looked at the exhibit, I'm trying to understand what you're arguing.
Yes.
Are you saying if the court had looked at the exhibit, considered the evidence or the argument of mother that it was prejudicing her, and said, I'm excluding it, then the father would have had to say, well, this is what the exhibit said, because otherwise the record would be zero.
Yes, Your Honor.
Okay.
And
So at that's what you're arguing, is that?
Yes, that his offering of proof would have occurred once the burden had shifted back to him. But I believe the burden first goes to for mother to show that prejudice existed, and for the court to inquire whether or not there's a lesser possible sanction. I do believe there's an offering of proof as to his complaint regarding his ability to cross-examine. On page 39, lines 8 through 14, he repeatedly attempts to ask and is interrupted if he can testify as to the truth of mother's statements. And when we review Arizona Rules of Family Law Procedure, Rule 44, even the 2018 version, the word shall is in there. It is mandatory language that is used in there. And I don't believe there's any case law in point that states that that right can be taken from him. As it relates to the distinctions in Christie, for all intents and purposes, father's rights have been severed or terminated. I don't take that term lightly. He went from joint legal decision-making to mother having sole decision-making. He went from having a 50-50 order to having zero parenting time outside of what was ordered with a therapeutic intervention. His children were ostensibly taken from him. And I believe
That's not a severance.
it's not a severance.
Because he
but
could
it
certainly
is-
work his way back into wherever it is he wants to be, but that's up to
He
him.
would if he was given 4 or 3 factors to try to modify in the future a benchmark, but without those in
Just
there.
saying this is a significant right, may not be as significant as.
Understood. Maybe speaking in hyperbole there, but the point was to the nature of the change. This was not going from every other weekend to 2 days a week or 1 day a week. This was a significant change to his parental rights. Again, as it relates to the comments that father did not participate in any way, shape, or form, I don't believe the record reflects that. Mother filed a petition for mediation. Father attended mediation. He attended the trial itself. And when looking through the sanctions under 76, there's a variety to choose from there, and I believe the case law requires that the court to look at and use discretion for which of those are appropriate. And there certainly could be the exclusion of some of his testimony. There could be exclusion regarding his financials to some extent if he didn't file the AFI, but the particularly high standard for exclusion of evidence as it relates to the best interest of the children, as articulated in Hayes v. Gama, requires that balancing test to be done. And the balancing test wasn't even considered by the court here, let alone accomplished. It appears the mother frequently refers to notice and what father should have known were he an attorney, what father should have expected, the benefits of the pretrial statement. And again, father urges that notice is not a panacea for all due process issues. And while father concedes there was notice that he should have filed his pretrial statement in AFI, again, the burden shifts to prove that there is prejudice before the ultimate sanction is taken against him. And the question, again, posited, that should have been posited to mother is whether she had seen these documents, whether there was a prejudice, whether they should be allowed based on the record and the due process violations. Father requests the court reverse and remand for a new trial on the merits. Thank you.
Thank you, counsel. This matter is now under advisement, and we will issue a written ruling in due course. We appreciate counsel's time and your preparation in this case. Have a good day.